Right of wife to Harta Sepencarian after divorce in Malaysia. The issues and the solution. Members of Group 3 that will be representing today is WAFIQOTUL IMAMAH BINTI MARKOM, WIRDATUL AMANDA BINTI KHAIRIL, NURUL ATHIRAH WANIDA BINTI MORDIN, Nurin BINTI ABDUL Aziz, NURUL ASYIKIN BINTI ABDUL HADI.
Introduction. This section explains the theoretical concepts of the topic, definition, authorities in Quran and Sunnah, as well as provision in Islamic Family Law Federal Territories Act 1984. In Section 2 of IFLA 1984 has defined matrimonial property as property jointly acquired by husband and wife during the subsistence of marriage in accordance with the conditions stipulated by Islamic law. Islamic Family Law Federal Territories Act 1984, Section 122, Clause 1, Clause 2, Clause 3, Clause 4 and Clause 5 of IFLA provided that the court may order the division between the parties of any assets by the ways. In the case of Hujalija binti Jamal and Fatimah binti Matiyah, 1950, the court held that the rule governing matrimonial property is not part of Islamic law, but a matter of Malay custom. But after the amendment of the Federal Constitution, the insertion of Article 121, Clause 1A, matter of matrimonial property can be heard in Sharia courts only.
In the case of Wan Khairina binti Wan Mahmud against Ismail bin Muhammad 2011, the court decided that the properties registered under the defendant's name were jointly occurred properties of the plaintiff and the defendant. In this case, the plaintiff had indirectly contributed to the needs of the family and the household. She had assisted the defendant by looking after the children and the household needs, while the defendant was able to effectively focus on his business. As a result, the court orders for the division of the jointly accrued properties with one-third to the plaintiff, who is the wife. Authority in the Surah An-Nisa verse 32, and do not wish for that by which Allah has made some of you exceed others. For men is a share of what they have earned, and for women is a share what they have earned. And ask Allah of His bounty. Indeed, Allah is ever of all things knowing. Authority in the Sunnah is according to Al-Imam Al-Shafi'i has said in his book page 328, meaning when there is a dispute between a man and a woman over the objects or appliances of the house, in which the two of them live in the house because they are separated, divorced, or even inseparable, or both die, or one of them dies, which in both cases the husband and wife died, or one of them dies, there is a dispute between the heirs to both parties, or a dispute by the heirs to one of the two parties, then the position of the solution is all the same.
There are 4 issues that will be discussed in this presentation. The first issue is the indirect contributions of a housewife is underestimated in the court. 2. Whether the inconsistency of the court decisions in several cases with regards to appropriate share to be received by the wife can be challenged. 3. Whether the court inclined to consider the financial contributions to the purchase of asset. And 4. Whether the court adheres to the literal provision that requires the consideration to only financial contribution of the parties and the indirect contribution of the wife was not estimated.
Next, we go to the implication. Those issues may cause some implications towards the society, especially among the women out there. This is because of the unfairness that happened to the divorced housewives, where their indirect contribution is underestimated in the court when it comes to the matter of Harta Sepencarian after divorce. As a housewife, normally her service is to take a good care of her family. it has been observed that the extent of homemaking contribution is confined to her physical efforts to serve her family as a wife and a mother in taking care of the husband and family. But after a divorce, it turns out that the court, in deciding the division of the Harta Sepencarian between the husband and the wife, literally follows the provision where the extent of to that, the court regards monetary contribution of spouse to acquisition of assets as preference and significant rather than a homemaker's non-financial contribution. And because of this provision, the housewife is tend to get a lower proportion. Regarding to the provision, the housewife might think the amount that she got from the proportion of the Harta Sepencarian is not worth it with the amount of efforts that she had been put into her marriage, even though it was just an indirect contribution. Therefore, this unfairness proportion of share could also bring into a fight between both parties. The wife might be unsatisfied with the decision from the court where she got the lower amount of proportion rather than the amount that her husband got. This shows that the unfairness division of proportion could bring into unpeaceful divorce between the husband and wife. This is not good in Islam where Muslims get into a fight with each other, and this could affect or influence their children to hate one of their parents. The innocent children should not be involved in a fight between their parents because it might cause them to stress over family matter, and there will be a chance for them to get depression. Kids might understand the situation which their family in, but still they should not face this kind of family problem. What I'm trying to say here is, the unfairness proportion of share could lead into a fight between the divorced husband and wife, and because of that fight, the children of theirs could be affected too, and this is not a healthy thing to be practiced when there are so many depression kids in Malaysia who comes from a problem family. Besides, there is also any other implication towards the society where they think that the women's dignity is underestimated, especially when a woman is just a housewife and did not give any financial contribution towards her family during the marriage. The husband might take an advantage after their divorce in the matter of Harta Sepencarian. This is because the husband is the breadwinner during their marriage, so he thinks that he has the rights to get a big proportion of the share. In fact, the wife still has the right to claim for Harta Sepencarian with her non-financial contribution, but she will tend to get a lower amount of it rather than the amount of her husband get, as has been told in those issues above. This might create some new negative thinking among the wives. To be clear, the wives out there might think that they need to work harder and not just being a housewife, so that if any bad thing happen to their family, they will not be too affected, especially with the lower amount of proportion that they got from Harta Sepencarian after divorce, and they could also give some financial contributions during their marriage. Being a hardworking mother is good, but it becomes not good when a wife and a mother is too busy with her work until she neglected her duty to take care of her family.
Suggestion on how to overcome the problems. Firstly, make the law that governs the division of matrimonial property. In Malaysia, we already have the law which we called as the Law Reform Marriage and Divorce Act 1976, hereinafter referred to as the LRA. Secondly, Supreme Court can order a judicial review to make sure that the indirect contributions of a housewife is not underestimated in the court. Thirdly, make law that is obligatory for the couple to make a contract under civil law of the division of matrimonial property if they decided to get divorced before they get married to each other. And lastly, the government should enforce the kursus perkawinan to give knowledge on the division of harta sepencarian after divorce.
In conclusion, this study has concluded that although the law of the division of matrimonial assets is stipulated in the statutory provision, the court still cannot follow the law due to the rigidity of the provision that causes inconsistency and lack of creativity in court practice. Therefore, in order to commensurate the actual practice of the Sharia Court, it is pertinent that the issue is resolved by amending the existing law to take into consideration a lot of other factors for fair and equal proportions in the divisions of assets. In this particular aspect, the mindset of judges has to be changed, where marital relationships should be considered as partnerships rather than focusing on the exact contributions of the parties in the division of matrimonial property. The revamp of the current law is indeed necessary to comply with the current needs in the contemporary society. That's all from us. Thank you.